Yes, this is the sentence. Each of the convicts hearing was in the judgment delivered on 13th of March 2026, found guilty and convicted of the respective counts as detailed in the judgment delivered in this matter. I have considered the submissions made with regard to the issue of sentencing and taken into account the submissions made by the first accused person and the fourth accused person hearing, and counsel for the second accused person, counsel for the third accused person, and counsel for the fifth and sixth accused persons hearing, and by the prosecution counsel. I have taken into account the mitigation made and perused the affidavits and documents filed and relied on during mitigation. Matters touching on merits of conviction were not open for canvassing at mitigation or pre-sentence stage, as the court does not sit on review of its own decisions at the sentence hearing or mitigation stage. I have also perused and taken note of the contents of the pre-sentence reports filed hearing in respect of each of the convicts hearing. Counsel for the prosecution and the defense made submissions with regard to whether a death sentence is a legal sentence which can be meted in a case where a person has been convicted of offense of robbery violence. There is no dispute that the convicts have been in custody during the entire period of the trial from the time of arrest. The court in sentencing is mandated under Section 333, subsection 2 of the Criminal Procedure Code to take into account the period of time spent in custody. This section should therefore apply to determinate sentences. The period of time spent in custody shall therefore be taken into consideration. I have gone through and taken note of the mitigations made in relation to each of the convicts hearing. A plea for leniency has been made in respect of each, and each has expressed remorse. The prosecution has not proved in the manner required the existence of any previous conviction in relation to any of the convicts hearing, and therefore each of the convicts hearing shall be treated in this sentencing as first offenders. I have also taken into account the nature of the offenses of which the respective convicts have been convicted and the sentences provided for the same. I have also taken into account age of each of the convicts hearing and their personal circumstances as reflected in the pre-sentence reports filed. I have also taken into account the circumstances under which the offenses were committed, and for the robberies, the fact that the victims, who were PW1, PW3, and PW4, were abducted in the course of the robberies, which were committed on the material night. The first victim having been carjacked and robbed, and his vehicle used to access the second set of victims by the same robbers who carjacked, abducted, robbed the second set of victims, that is PW3 and PW4, before being abandoned that night. While the first, second, and third, and fourth convicts have indicated remorse, the offenses are very serious, and the victims also deserve justice. The offenses were committed with utmost impunity, armed with rifle previously robbed from a police officer. The circumstances in which the robberies were committed call for the sentences provided for at section 296(2) of the Penal Code. The decision of the Court of Appeal in the aforesaid Miano case, a decision made on 25th of March 2026, is clear on the position of the law with regard to the sentence provided for under section 296 subsection 2 of the Penal Code. Decisions of the High Court So the decisions of the Court of Appeal take precedence over decisions of the High Court. I consider the following sentences reasonable and appropriate. A, count numbers 1, 2, and 3, each of the first, second, third, and fourth accused persons or convict is sentenced to death as by law provided on each of the said counts numbers 1, 2, and 3. However, as by law required, execution of the sentences on counts numbers 2 and 3 shall be held in abeyance because the sentence on the first count renders the same sentence on the other counts with regard to the same convicts moribund. B, on counts numbers 4 and 5, which relate to the first and sixth accused persons only, each of the first and sixth accused persons is sentenced to 10 years imprisonment with effect from the date of first committal to remand custody. C, on counts numbers 6 and 7, which relate to the second accused person only, the second accused is sentenced to 10 years imprisonment from the date of first committal to remand custody. On count number 8, which is against the fifth accused person only, the fifth accused is sentenced to 10 years imprisonment with effect from the date of first committal to remand custody. Sentences imposed on counts 4, 5, 6, 7, and 8 shall run concurrently for the respective convicts. Also, execution of sentences in respect of counts 4 and 5 for the first accused person, and in respect of counts 6 and 7 for the second accused person, shall be held in abeyance in view of the sentence imposed in respect of the first 3 counts. Firearms and ammunition produced in the course of this trial shall be forfeited to the state. However, since there is a related murder trial still ongoing before the High Court against the first to the fourth accused persons, the order for forfeiture shall take effect only upon conclusion of that trial. Any party to the case who is not satisfied with the conviction or otherwise in relation to the person who was the seventh accused, or any of the sentences or both, has the right to appeal within 14 days from the date hereof. Typing of proceedings be done and the same be supplied to the convicts or their counsel upon receipt of the formal request to the registry in the normal manner. Orders accordingly. The sentence is typed. It shall be uploaded to the portal within the next 5 minutes, so the counsel on record will be able to get their copies online. So I think that marks the end, and thank you.